Hi. Something that came up recently, which I'd heard about in the past and had an experience for myself in the 9 years I've been in practice, is somebody got appointed to be a successor in a document, in a will and a trust. So the idea generally is people set up documents and they provide a primary person to represent them. I personally always recommend that you do a backup. You just never know what's going to happen. And this gentleman had been appointed a successor, and he did not know it until after the person died. He got a phone call out of the blue that said, "Gee, Jim, Susan appointed you to be the successor to her husband, who's already dead, as trustee, to have him say, 'Excuse me,' and then say he couldn't do it because of the kind of job he has. He's a professional, he sells insurance, and he only knew this woman because he had sold her a very small policy. This is all to say that when you're going about doing your estate planning documents, any of them, whether you're just doing a power of attorney and a healthcare surrogate, you need to either ask people in advance or you need to get their permission before you have somebody create the documents. And even if you don't, you need to let them know. I mean, by this gentleman not knowing previously and then not being able to serve, he's complicated. He has not complicated. That's not fair. The situation has been complicated because now we have to find a way around it. And it might be problematic just because he's a professional in the financial services industry. Usually that doesn't happen. It could be as simple as you appoint your sister-in-law to be a backup. And she just at the moment that you're asking her, at the moment she's called upon, she's not in a physical or emotional position to do it, having nothing to do with whatever's going on. So when you're appointing people, when somebody says, "Who do you want to appoint for the first position or the second position?" please ask them first. Don't put them in an untenable position of having to say no for any reason. And don't leave your family, if they need somebody in that position, where they're scrambling. There's always somebody who can be found. There are professional fiduciaries who fill those roles. Those cost money. Again, it's the first time it happened to me in the little over 9 years actually I haven't been in practice 9 years, but the little over 9 years that I've been an attorney. And you don't want to do it. You want to look, if you have documents, you want to look at them and you want to say, "Oh, I just decided that my cousin Susan would do this. I never talked to her about it. I never asked her about it. Wow, she and I aren't even talking anymore." But even if you are, you want to ask. So don't make it difficult for the family. Again, I've said it before. When somebody dies, if their estate is in proper working order, so to speak, whether it's $500 or $500 million, their family should only have to grieve. That's all. That's all. Yeah. And if you were confused at all by what I said, and I know there's something scrolling across the bottom, please reach out to me, because anything I said applies in any state. I can only practice law, like do documents in Florida, but what I just shared about this would be germane, relevant, any state you live. And I don't charge for my consultations, and I am driven to be of service. So thank you. Thanks for watching. Have a great day.